Good afternoon, everybody. Welcome to this afternoon session of the Governor's Council. My name is Councilor Eileen Duff, and I am chairing today's hearing. I'm going to read the letter from the Governor, and then we shall begin. Dear Councilors, I am pleased to nominate Susan H. McNeil to the position of Associate Justice of the Lawrence District Court. I submit this application for the advice and consent of the Executive Council pursuant to Part 2, Chapter 2 of the Constitution of the Commonwealth of Massachusetts. I am enclosing the nominee's resume for your convenience. And there we have her, our nominee. Okay, so on this, let us call Attorney McNeil's first witness. And will that be the Judge Mary McCabe?
Yes.
All right. Thank you, Judge McCabe. We'd love to hear from you.
Apologize that I'm not there in person. I'm covering Haverhill and Somerville today, and apparently I'm also not there visually, so I'm sorry for that.
That's all right. We're in a pandemic, and we appreciate you taking the time.
Well, by way of introduction, I will say I'm a district court judge and have been for 8 years, and that I am here unequivocally and enthusiastically to speak in support of Attorney Susan McNeil. I've known Susan in a number of different roles, the first one being as when she was my adversary in the district attorney's office. She was exactly what one would hope for in a DA. She was professional and smart and ethical with no hidden agendas and compassionate for all parties. She was an aggressive advocate when it was appropriate, but also a practical ADA who recognized if a case was a weak case. When she left the DA's office to go into private practice, Sue knew enough to know what she did not know, and came to me because I had had a private practice for about 10 years. And she came to me about all the many questions that too frequently are not asked about how to run a business and all the accounting concerns. And as time went by, if she had conflicts or she needed a co-counsel or she had an area where she might not have known what she needed to know, we met often. I quickly began to rely on her expertise just as much as she relied on what she perceived to be mine. She had a lot of civil knowledge, and in addition to lots of criminal knowledge, and I worked with her on cases. In the process, we developed a friendship, sharing, among other things, the fact that both of us spend a lot of time working in the area of people with special needs. Most importantly to me, though, when I went on the bench and had to give up my practice, I asked Susan if she would represent all my criminal clients, and I gave her those clients. This was particularly important because as a private practitioner, these were people I knew and people with whom I had a relationship. I had invested time in them. I knew their cases. I was part of their lives, and they trusted me. To a person, these clients were extraordinarily satisfied with Susan's replacement of me. They were, to a person, were pleased with how she responded to them, how she represented them, the job that she did for them. So I can only say that that piece alone was so important and so incredibly well handled that in terms of my current job, I would be thrilled if she were a colleague. She's smart. She works hard. She's generous with her time and generous with her skills, but she knows her limits. She's got a varied legal experience and a varied life experience, and she's really fun. I think these are the kinds of things that would make a great judge, and I would be completely delighted if she were a colleague. And that's, I guess, all I can say today about Susan.
Thank you very much, Judge McCabe. Do any of my fellow counselors have any questions they'd like to ask of the witness?
Yes. Terry Kennedy, Madam Chair, could I speak to the witness for a minute?
Yes.
Judge, how are you?
Very well, thank you, Mr. Kennedy. Nice to see
Judge,
you.
I just want to tell you that a little while ago, I got a text message from the Somerville District Court clerk saying, Judge McCabe testifying before you today. We've been using her remotely. We love her. I just wanted to tell you I got that. That's
Well,
all.
thank you. You're not looking for a continuance or anything, are you, Mr. Kennedy?
I'll be over this afternoon. I got about 20 of them for you.
Denied.
Me, Judge? How could you suggest that?
Thank you, Mr. Kennedy.
Nice to talk to you.
And thank you for that nice compliment. That's nice to hear.
Thank him.
Any other counselors? Okay, no counselors. Thank you so much, Judge. I thank you for your service. Haverhill is in my district, and we're very pleased that you are sitting up there as well. So thank you.
It's my great pleasure. Thank you so much, Counselor.
Thank you as well. Do you have another witness, Attorney McNeil?
I do. Attorney Ron Ranta.
Okay, Attorney Ranta. Terrific.
Good afternoon, members of the council. By way of introduction, I am in private practice in Danvers, Massachusetts, and have been a member of the Massachusetts Bar for the past 42 years, 8 of which were spent as an assistant district attorney in Essex County. I am honored to be here today in support of Attorney Susan McNeil for the position of Justice of the District Court. I have known Attorney McNeil for over 25 years. I first met her when she was an assistant district attorney at the Lawrence District Court. I had a number of cases there, and it seemed Attorney McNeil was always the district attorney assigned for the Commonwealth. She proved to be a formidable opponent. She litigated the cases zealously and ethically, 2 concepts that were never at cross purposes with her. We were constant opponents, and through that adversarial relationship, we became good friends. She clearly understood her role as an advocate. She was not a crusader, but a hardworking assistant district attorney representing the citizens of Essex County. She understood and took the time to hear the arguments of opposing counsel, not just look for ways to counter them, but also to find if there was a potential common ground. Her intelligence and common sense were readily apparent to all who dealt with her. I often found myself about a fact pattern in some case in which she was not involved. What made her such an effective advocate was her ability to see all sides of any issue. She took the time to listen to the arguments of others. She had the ability to see the other side, not just as a name on the other side of Commonwealth, but as a person, and had the capacity to be empathetic to the situation of others. When she left the district attorney's office, she began private practice. We handled a number of cases together, representing co-defendants. She works extremely well collaboratively, both giving and receiving advice. For the last 8 years, we have worked out of the same office suite in Danvers. During this time, I had the opportunity to seek her out as a sounding board where I could bounce my ideas on how to handle a particular issue or case. Her insights were always informative. She led me to see things from a different perspective. I have known her as an opponent, co-counsel, and friend. Though the dynamics of our interactions have changed, she never did. To be here today as a witness in support of her nomination is one of the highlights of my legal career. I am honored to be able to support someone whose appointment to the bench will be a gift to the citizens of the Commonwealth. They will have a judge who has intelligence, common sense, a strong work ethic, and a judge who is empathetic. a judge who will listen to all those who come before her, who will judge them by the validity of their arguments and not by their station in life, who will have the courage to make the difficult decisions, the unpopular decisions, but most of all, the right decisions. And I thank you for giving me this opportunity.
To have you here. Thank you for taking the time to come. Do any of the attorneys, to any of the councilors have a question for Attorney Ranta? Hearing none, you may step away. Thank you, sir. Are we back? Okay. Do you have any other witnesses, Attorney
I do
McNeil?
not. No.
Is there anyone else there that would like to speak in favor or in opposition? If so, please come forward. Hearing none, I will turn it over
There was a line outside the door.
Let me check. Oh, they left.
Okay, I will turn it over to you, Attorney McNeil, for your statement and to introduce anybody that you'd like to.
Thank you very much. Good
My
afternoon,
pleasure.
members of the Governor's Council. As you're aware, my name is Susan McNeil. I'm an attorney practicing as a sole practitioner in Danvers, Massachusetts. I appear here today with my husband of 25 years, Ralph McNeil, and with the support of my two children, Emma and Duncan, who are both in college, as well as the support of my parents, brothers, and all of my extended family. I want to thank Governor Baker and Lieutenant Governor Polito. I'm truly humbled and honored by the governor's nomination that brings me before you today. Born and raised in Lawrence, Massachusetts, the youngest of three kids with two older brothers. I attended elementary schools in Lawrence, high school in Methuen, and then I went on for my bachelor's degree from the Eisenberg School of Management at UMass Amherst. From there, I went on to attend Suffolk University Law School, where I earned my JD, and I've been practicing law ever since. I'm very fortunate to have had such a variety of people and cases cross my path in the 27 years I've been practicing law. Given my time as a prosecutor, as well as running a diverse practice, I feel that I bring a wide range of experience to the table. As a prosecutor assigned to one of the busiest district courts in the Commonwealth, Lawrence District Court, I had the opportunity to be in court every day, doing some sort of evidentiary motion or trial almost daily. I was quite lucky to have been surrounded by some very experienced prosecutors and skilled members of the defense bar, from whom I was able to learn a lot about practicing law. As a young attorney, I was also very fortunate to have appeared before a wide range of judges who taught me a great deal about courtroom decorum, when to speak, when to listen, how to win with humility and lose with grace. I gained valuable experience during my time as an ADA, handling motions, bench trials, jury trials, grand jury presentations, and speaking with victims and families, all while balancing a chaotic schedule. After I had several years of experience as a prosecutor and in recognition of my trial advocacy skills, I was put on the training team and tasked with helping new ADAs learn the ropes. The training team was responsible for conducting mock trials, and we also were mentors. As a mentor, I would sit in on motions and trials to help build the confidence of a new ADA and to ensure that they had a resource available to them for their in-court proceedings. I'm proud of my time as an ADA and have always considered it an honor that I was trusted to train new attorneys to do the job well. I was fortunate to have formed friendships with several defense attorneys whom I respected and trusted during my time as an ADA. When I made the decision to leave the DA's office, I had resources that I could rely upon to guide me in my practice from this new perspective. It was shortly after our daughter was born that I left the district attorney's office and went into private practice, only to find out weeks later that I was pregnant with my son. After our son was born, and with the help of our family, I was able to build my practice in Lawrence. I had seasoned members of the defense bar to rely upon as I learned the skill of defense work. Throughout my time as a defense attorney, I handled virtually every type of case imaginable. I've handled everything from cases involving trespassers and disorderly persons to OUIs and gun cases. I've been on the defense team for homicides. I've handled cases with significant media coverage, including kidnappings with mental health issues and criminal harassment. In addition to criminal work, I also had the opportunity to handle a wide variety of civil matters, from restraining orders and licensing issues to multi-million-dollar cases in federal court and in the superior courts of Massachusetts. Regardless of the type of case, large or small, I care about my clients, and I think they have all benefited from my ability to really see matters from both sides of the aisle. When analyzing any case, after reviewing the facts, I always try and look at the matter from the other side's perspective, and in doing so, highlight all the issues in a case. Ultimately, my goal has always been to get my client the best outcome possible while working within the constructs of the rules, ethics, and laws. I'm proud of my record and all that I've been able to accomplish. I hope that you find my background and experience make me a suitable candidate for the position of Associate Justice of the District Court. I thank you for the opportunity to be here today, and I welcome any questions you may have.
Eileen, we can't hear you.
I think Councilor Duff is muted.
Still can't hear you, Eileen.
Been unmuted, I've been told. Can you hear me?
Yes.
Yes.
All right, you probably wish you couldn't. So Attorney McNeil, I usually, as the chair, go last, but I have some questions and concerns, and from a constituent in my district. So I want to address it head on right at the beginning of the hearing, and it was in your application as well. So I don't want to, this is not a gotcha. I don't want to catch anybody off guard. But I did receive a correspondence from the family of the child that was kidnapped in opposition to your appointment to the bench. I'll be honest, and I don't know if other councilors saw it or not. It didn't have any specific reason why about you, why you weren't competent or should be on the bench, other than that they were upset that you had given representation to the person who kidnapped the child. And I actually would like to say some more things as well. Did you
I'm
hear
sorry,
me?
could you repeat
You went out.
the last part you cut out?
I'm sorry. I would like you to address that case. I remember this case quite well, actually. And it was, as any case with a child and a small child, it's scary and shocking. But I'd like you, in your own words, to explain the case as you remember it or know it, and why you chose to represent this person.
Certainly. I remember the case very well. It was a horrible, horrible situation, a horrible kidnapping. As a parent, I can't imagine the position that those parents were in when they found that crib empty first thing in the morning. Thankful every day that I was never in that position. However, I was contacted by another parent, and that was the parent of the defendant whom I represented. And I was told that she was being questioned presently in the home by the police. And I was also informed that she had had mental health issues since the age of 12 years old. So I made the decision to get involved in the representation. And I represented her fairly, ethically, and zealously throughout the process. But it took us quite a while to get her to a state where she could even effectively participate in the court proceedings because of her mental health issues. I don't regret getting involved in the case. If I had it to do over, I would take the representation again. I think everybody is entitled to a defense, and I think I did a good job for her. But again, the situation itself was a horrible situation. It was a horrible kidnapping. I feel every empathy that I can for those parents. But my job was to defend Ms. Hannah.
Well, thank you. And I, that is what I suspected. I'm sure that the parents, I also understand from my own research that this young lady was introduced into the family through the parents, so I'm sure they harbor some, guilt about that. You don't know when you're interviewing somebody sometimes if they're not right. And even when you suspect it or sort it out, no one ever expects that someone's going to come back to your house in the middle of the night and steal your kid. So that is just a horrible, tragic thing that happened. I do want to say on this same issue, though, that I received, and I sent it out, I received it, I believe, last night. And I'll read it I'm going to read the whole thing. I don't usually do this, but I want to do it. It's from the attorney who actually was on the other side of the case. And to me, as Attorney Ranta said, it means a lot when your adversaries speak on your behalf. So this is written by attorney Kristen Buxton, who works for the DA's office, who was counsel against you. She wrote, to the Honorable Eileen Duff, I write to you in support of the nomination of Susan H. McNeil as Associate Justice of the Lawrence District Court. By way of introduction, I'm a 23-year prosecutor from Eastern Essex County District Attorney's Office. I've served as an assistant district attorney on behalf of Kevin Burke and John Blodgett. I did not work directly with Attorney McNeil when she was a prosecutor. My support of her arises from my knowledge and interactions with her as her role as defense counsel. In my experience, Attorney McNeil is diligent, prepared, smart, and a committed advocate. One of her most impressive qualities is that she is able to advocate strongly for her client while treating both sides with respect, care, and dignity. She's an excellent lawyer without question. She's also thoughtful and fair-minded. Over the years, many of our conversations have not just been about the particular case we are handling, but about broader legal issues or our experiences in the courtroom. We discuss victims, defendants, and their respective families. Through these conversations and interactions, I know with certainty that Attorney McNeil sees and respects the humanity of each case and sees and respects the effect that each case has on people on both sides of the case. I believe in the decency, fairness, and compassion she has demonstrated as an advocate make her an excellent candidate to serve the public as a judge. Please accept my enthusiastic support of her nomination. I hope you will share it with your fellow counselors, and please don't hesitate if I can be of any further service to the council. With kindest regards, Kristen Buxton. I also, late in the afternoon yesterday, received a call from somebody who can be very, very tough, and that is DA John Blodgett, who also spoke very highly of you. And I asked him point blank about this case because the parents were upset about the nomination. And as any parent may be, we've seen it before. Parents get upset when something's happened to their child. The child's been involved in a case, and somebody who's been involved in the case on the legal side gets appointed. DA Blodgett had the highest compliments for you. And one of the things that was shared with me, and I'm going to share this publicly, is that through your counsel, you were able to help this young woman who committed the crime to understand exactly what she had done and why it was wrong, and change her plea to guilty. And from what I understand, the paperwork and the history of her mental illness was so large and convoluted that Judge Dressler, who heard it, really took into account all sides of this. Now, the prosecution didn't get the sentence they wanted, but this woman is getting the help she needs. She is serving at MCI Framingham, which is no light lift for anybody. I've been there. I visited prisoners there. And although she may have been eligible for parole, and she may be eligible for parole, that doesn't mean she'll get it. So, and people need to understand that about parole. Because someone has the right for a hearing doesn't mean they will be granted it. So, anyway, I wanted to bring that to the forefront because it's this type of thing that can get sensationalized, and I have great sympathy and deep feeling for this family, and I can understand they're naturally, as any parent would be, terrified that another family might experience the same terror that they did. But it's not a reason to not. It's not a reason for you not to be appointed to the bench. And in fact, I think that one of the most important things about being an American is our right to counsel and our right to defense, and that you are innocent until proven guilty, and that you were able to get this woman to understand that she had committed a very, very egregious and serious crime. So, anyway, with that, I like to put the elephant in the room right out there at the beginning, because I don't want it to turn into anything sensational. Thank you for addressing that. I'm sure other counselors may have questions. They may not. On that particular case. With that said, I will start with Councilor Fiera as he represents District 1.
Thank you so much. I've spoken to Attorney McNeil before. I certainly have no issue with her representing somebody charged with a crime. I've done that myself, even though I was a police officer for 30 years. I do that now. And my good friend, Councilor Kennedy, does it every single day in multiple courts. So that's our system, and that's what makes us a great country, that we have a system like that. I also had my arm twisted very rapidly by Councilor Kennedy early on in the process. Told me you're a rock star. He's a guy that's been in and out of courts in your neck of the woods for 40 years. I put a lot of trust and confidence in what he says about people. And I also get other calls from people in your neck of the woods saying that you're going to be a great judge someday. I am not one to carry on unnecessary questions that I know the answer to. But I want to thank you, as somebody who served 30 years in law enforcement. I want to thank you for your service to the Commonwealth and to the DA's office of what you've done. And you have my vote next week.
Thank you.
Thank you.
Well, that's very powerful. Thank you, Councilor. Is Councilor Jubenville with us?
No.
Okay, well, if he joins us, we will go back to him. Councilor Devaney.
Thank you, Counselor. First of all, we met for 4 hours, and I found out a lot of things after we have met. And I'd like to, I want to say first, compassion is one of the attributes I look for. I won't vote for anyone that they don't have empathy and that they don't have compassion. So having said that, I understand very well your position. Everyone has the right to be defended, and that's your job. So let me talk about that, okay? This is not the norm that I do. Okay, just for the record, you applied when, and when did you get the JNC appointment?
When did I get the JNC appointment? I applied this last time in October, and I was contacted by the JNC in April, I believe.
Okay. And how many of the 21 attorneys who are charged to choose a nominee to give to the governor for a judgeship? How many were there of the 21 lawyers?
I believe that when I interviewed, there were 7 at the table, and I believe that there were 5 on the conference.
So 7 were present. Okay. First of all, I think the most concerning thing to me is, all right, let me go on about this event. On November 20th, 2015, a 2-year-old girl was kidnapped from her bed in the middle of the night
She was tortured, burned from head to toe. She was assaulted and left naked on the side of a street. It was a highway in the freezing cold. Thank God, 2 good Samaritans found her. She was nearly dead, and the first responders arrived. This poor little girl, 2 years old, was burnt over her entire body, even removing her diapers to burn her private parts. All her hair was cut off, leaving her with cuts all over her head. This precious little girl is 7 years old now, and she will always relive that nightmare. She will never get over the torture, the cruelty for the rest of her life. She was left to die naked, freezing in a street by Abigail Hannah. This little girl is still afraid to even put on her socks in the morning because of the scars on her feet as a reminder every single day of her torture. The Albers, the parents, had hired Abigail Hannah as a babysitter. When she didn't show up, they fired her. So now she has, this is the thing that really concerns me, your compassion. You asked the judge to give Hannah a 3-year sentence. 3-year sentence for nearly killing a child, torturing her, assaulting her, burning her, cutting her, leaving her naked in the cold to die. And that's where I go. Compassion. Where was your compassion? You're so proud of it. You said you'd do everything the same again. I heard you say that. That's fine. Okay, so Abigail Hannah has gone before the parole board twice in the last 2 years. And it was learned at the parole board that this beautiful, innocent 2-year-old girl was not her only victim. The parole board rejected her, and they told her her mental issues didn't rise to the level, and there are people with mental issues do not kidnap and try to kill a child. The sad thing is, she'll be out next year. But you wanted 3 years. You thought 3 years was enough, and the judge gave 5 to 7, so she'll be out next year. The Albers sought help from the governor's office. They received no response. They even wrote to the governor a year ago to talk about the failure in the system. They want to help. They want to show their experience. They want to correct it. They never received a response from the governor's office. Now, Abigail Hannah is classified as a level 3 sex offender by the Register Board of Massachusetts. The Department of Corrections, this is so incredible, the failure of the system, had approved for a move for Hannah to go to a minimum security facility, making her eligible for community work crews. Imagine the victim, the Albers, had to educate the Department of Corrections about Abigail Hannah having sex offender status. And so she wasn't moved. And so, you know, it just, I just can't imagine how you could stand before the judge and ask for 3 years. How can you reconcile that? How can you think that 3 years was enough?
I represented a woman who had established mental health issues from the time she was 12 years old. She came before the court with absolutely no record. And I ran the guidelines for what she was indicted for. And when I ran the guidelines with the indictments, with the charges she faced, the initial run of the guidelines called for a 3 to 5 year sentence, was my belief. And that's what I asked the court for, because that was the Superior Court guidelines called for her indictments. When I was in court and before Judge Drexler, he had pointed out that there was an additional section. We factored that section in. The guidelines then came to a 5 to 7. I filed a new sentencing memorandum asking the court to follow the guidelines of a 5 to 7. I filed my sentencing memorandum asking for that with some very stringent mental health concerns. She has to, what her follow-up care is. She'll be followed for 10 years. She has a GPS bracelet. She has to stay out of Hamilton. She has to stay away from children in public parks. But what I did was run the guidelines for the indictments for which she was charged, and I asked the court to follow those.
Can you imagine how the Algers feel? Talk about putting salt in the wound to learn that the attorney who recommended the short sentence for their child has been appointed by the governor when they have desperately tried to talk to him and they want to change the system. It's a failure. The Department of Corrections, they had to educate them about this woman. So the Algers aren't looking for publicity. They want to be private. They're trying in their way as activists to be problem solvers. They want to talk to the governor. They haven't been able to, they can't. So they don't want anyone else to go through the nightmare that they have lived. They are doing everything to reach out. And that's why they reach out to the governor, but unfortunately, the reaching out wasn't returned. So they even are running in a New York marathon for the National Center for Exploited and Missing Children. They want to make a positive out of the nightmare they lived. They don't want anyone to go through the nightmare that they have lived. And her child will never have a life that our children grew up going through that trauma. And I cannot imagine that there wasn't a way that you could have suggested to the judge that she get more than that. She nearly died, this child, 2 years old, a baby. You know, I just can't even imagine. And you're so proud of what you did and you do it all over again. That's great, you know, but for me, you lack compassion. You talk about her. You never mentioned the child here today, never told about what this child is going through, a 2-year-old. I've had 4 2-year-olds, and I have 4 grandchildren that were 2-year-olds. I can't even imagine what this little, precious little baby went through. But you never mentioned it. You're proud. You're proud of what you did, and you do it again. And I can't believe that you wouldn't be able to ask the judge to give more years. I don't believe it. And the thing is that next year she'll be out. And in the parole board, they showed that she's a sex offender, and she has assaulted other children. And thank the parole board, very proud of them. She went before them twice, and they rejected her. You know, the other thing is, it hasn't got to do with it, but, you know, there's a new rule that, new law that you can, for good behavior, you can have 15 days taken off a month of your sentence. You know that? Yeah, I know it too. And I'm just saying that, you know, when you think of someone like that, and you can talk about the mental issues. You know, we all have people in a family and friends that have mental issues, but it didn't rise to that level. And the parole board said, we have people that come before us with worse mental issues that you are telling us about. And they do not kidnap and torture and nearly murder children. So that's where I am. And so, you know what? I've never done this before, but I said I'd never vote for anyone who doesn't have compassion. And you obviously have shown that today. And I am going to ask the governor to withdraw your nomination. I know he won't. I know all the councils will vote for you. They have not voted against one person from parole board to judge in the Baker administration. So I understand that fully. I know that I'm a tuxedo with brown shoes up here. I know that. But I work hard and I do my job. And I'm thinking of the Alges, and you did not even mention that child. So the other thing is, I am going to ask the governor to meet with them. Give the Alges their due. What a disgrace not to meet with them. Even a year ago, they went to him. And they know the failures in the system, and they want to help improve it. They want to be positive. Like I said, they want to go through this negative nightmare and make a positive. They don't want anyone to ever go through this again. So that's all I have to say. I can't tell you how disappointed I am in you. You are qualified. You got the experience, all of that. But compassion, empathy. And so, I don't find joy in that. I don't find joy in it. But I have to tell you, because I vote with my heart and my head, and I don't leave a stone unturned. And everything I have said here today is factual. And my heart breaks. And even talking about that child, I want to cry, because she'll never have a fulfilling life. Okay? So that's it. So that's my statement, Counselor Duff, and I thank you for the time.
Thank you, Counselor. I would like to reiterate in this that every person in the United States has the right to a defense counsel, to vigorous defense, and that Judge Dressler is the one who ultimately made the decision what the sentence would be. I don't think somebody should be faulted when they represent someone who has clearly committed a heinous crime. I think it is quite clear that the prosecution understood this, and I feel terrible for the family that they brought somebody into their child's life who then committed a crime against the child. That's a terrible thing to live with. But it does not mean that the person who committed the crime doesn't deserve representation, nor does it mean that you have no compassion. So just on that, let's go to our next counselor, and that would be Counselor Iannella. Is he with us? If he is not, I will move on to Counselor Kennedy.
First of all, congratulations on the great job you did in that case. You did exactly what you were supposed to do, what you and I do every single day. It would have been unethical for you to recommend something higher because you felt the person should be punished more. You get disbarred for that, okay? Period. We represent some people that we're not having over for dinner necessarily, okay? So I've represented people charged with rape. I've represented people charged with rape of children. I've represented people who have committed horrendous crimes on people. It doesn't mean I'm them, and it doesn't mean I don't have compassion for the victims of crime. I do, like I know you do, okay? So to suggest that you shouldn't do your job in representing this severely mentally ill woman, who people should have compassion for as well, okay, is absurd. Now, I've known you for a very long time, Sue, okay? I've known your husband for a very long time. I have cross-examined him many times in court, okay? All on a professional level. Over the years, he and I have become very, very friendly, even though we've been on opposite sides of a case. I've had cases with you when you were a DA. I've had cases with co-defendants with you as a defense lawyer. You are a superstar lawyer, period. I have great sympathy for the folks, for the parents of that little girl.
As do I.
And I know you do. I know you have a lot of compassion. I've seen it in you. I have the greatest sympathy for that young girl who went through that trauma at a very young age, and it probably will affect her forever. But I also have sympathy for that severely mentally ill woman who was charged with this crime, who may or may not have been legally responsible for it at the time. I don't know the facts of the case, and I'm sure you explored that as a potential defense, and I'm sure that potential defense weighed in very heavily in terms of what the ultimate outcome of the case was, in terms of negotiations, and things like that. What was the Commonwealth's recommendation in that case?
10.
10 years? You're a superstar. I'm voting for you next week. There's nothing to talk about. If anybody should be on the bench, it's you. And in terms of that case, you did exactly what you did with respect to the oath that you took when you became an attorney.
Thank you.
Okay, the next counselor will be Counselor Hurley.
Thank you. Good afternoon. We talked at some length, Attorney McNeil. And I received the same letter that I think all the other counselors received, and that Counselor Devaney spent a lot of time reading. My family member was the victim of a breaking in to her apartment and having someone attempt to rape her and beat her. And as much as I personally would have liked to have seen that defendant burn in hell immediately, that's not the way our system works. And for anybody not to understand that the first job of a defense attorney, whether they like what was done or not, they have an obligation, having taken an oath, to do the best job they can for that client. I feel deeply for the mother and father of that child and for that child. There is no way that anybody can give that child back her childhood or those parents a sense of safety for that child. And in your opening remarks, I felt that you were empathetic as a person and as a parent who said, as a parent, you couldn't even begin to understand the pain and suffering that those parents went through. And for one of the other counselors not to understand that it was because you did your job that you're before this council today. It's because you did what had to be done. As onerous as the actions of your defendant were, she was not mentally right. And it is a legally recognized offense. And we shouldn't be judging people based upon our own personal belief as to what is right or wrong. If you do the job that you swore to do and you do it well, honorably, intellectually honest, as well as emotionally and mentally honest, then you have done a good job and you deserve to be nominated as a judge. Those parents feel so much frustration and anger with the system, as we all have at times, and me included, being a judge. But you have to stay within the bounds of what is proper in the role that you're in. And to my way of thinking, as Counselor Kennedy said, you have done that and done it well. And I will indicate also that I looked at your application, as I do with all of them, and you did everything right. You did what was right. And your depth and breadth of experience for the district court is going to serve you well, and it's going to serve the people of the Commonwealth well. To say I'm not voting for somebody because they did a good job on a case is absurd. And it goes to the very core of why someone doesn't understand our legal system the way they should. And if she did, she'd be saying, I hate what you had to do, but I respect what you did do. So I'm voting for you next week. My sympathy to those parents and to that child, but at the same token, and my father was a defense attorney for over 50 years, you don't pick your clients. and you have an obligation and an oath to do the best job you can. So thank you.
Thank you.
Thank you. I believe this Council Jubenville joined us. And Council Jubenville, thank you. I know you're very busy. Would you like to ask the nominee some questions?
I would like to ask her some questions. I also would like to make a little statement. Good afternoon, Ms. McNeil.
Good afternoon.
So I want to remind the counselors and you probably all heard of John Adams, who we speak of often at the council, and we, for the most part, admire for what he did in our country. But people sometimes forget that he was an attorney. And there was a very famous case called the Boston Massacre, when citizens of the Commonwealth were shot in front of the what is now the old State House, and 6 or 7 of them were shot and killed. And John Adams was asked to defend the captain who was present. It gave the order to fire. He was representing him, and he was threatened with his life. He was shunned by citizens of Boston, but still he pursued the case and defended the man as best he could, and got a not guilty for him in front of a jury in Boston. And he suffered greatly for that with the citizens of Boston and the newspapers. But he did it because he said that's the job of an attorney. I've heard it said that some crimes are so heinous that friends and families of the defendant won't stand with them. Neighbors won't stand with them. And in some countries, that's true. There is no lawyer appointed. There's no lawyer standing with people. But in our country, no matter how bad the crime is, in a courtroom, there'll be a lawyer standing next to that defendant. And after 42 years of practicing law and still practicing, and I was on the murder list in Massachusetts for 30 years, you take cases where you go into a courtroom, sometimes there were 50, 60 people in that courtroom. And everybody in that courtroom probably hated my client. And I'm the only one sitting with him. It's a pretty daunting feeling, I must tell you, and have to get up and cross-examine witnesses and make a closing argument. Many times I sat next to a defendant who I personally disliked. Not so much because of the crime he committed, because of the type of person he was. But my job wasn't to like him or dislike him. My job was to see that justice was done and he got a fair trial, which is the cornerstone of our entire system. We don't guarantee verdicts. We try to guarantee a fair trial for every citizen of this Commonwealth. So I know how you felt representing this person. I agree with my other counselors that said you had a job to do and you did it, no matter how untasteful. I want to ask you a little bit about the case. Tell me a little of the background. I must say I came on late because I couldn't get on this thing. And so I finally got on, but tell me some background of this case, how you got involved in it and what the situation was.
The case was a kidnapping. It was a horrible, just a horrific situation. The parents woke up in the morning to find that the baby was not in the crib, and they.
Can I ask you? Was there any relationship with the defendant in this family?
She had babysat for them one time. The plan was for her to be sort of like a nanny for them. However, she didn't show up for work for several days in a row. She had only babysat the one time and then didn't show up for work, so they fired her. And then this was some months later, about 2 months later, she showed up in the middle of the night and apparently took the child from the crib in the middle of the night. She then, they called the police immediately, and within hours, She was being questioned at her home by the police. Can you hear me? Okay. She was being questioned by the police at home. I had actually just finished a case in Lowell. I had an attorney there that I did not know, knew the family, and saw me. I actually had just won a case on a motion to suppress an armed robbery case, and called the family and said, "This is the woman you need to contact." And they called me, and I got involved that day. From the day she was questioned, she immediately went into the hospital. From there, she was brought into court, arraigned, and then spent the next 5 months at the Worcester Recovery Center on a 20-day commitment, was there for 5 months. And the Commonwealth's expert examined her as well and determined that she needed to remain at the Worcester Recovery Center for her mental health issues. When she was finally brought to a point where she could be competent, it took about 5 months before she'd speak to me. I went over the facts, went over all of the options, went over what I thought we had for motions to suppress or dismiss, explained to her how a trial would go, explained to her, basically all the options that she had. She made the decision at that point that she wanted to take full responsibility for her actions. I asked the court to consider this as an early acceptance of responsibility because she could not have done it sooner. And Judge Drexler agreed. We had a sentencing hearing. I briefed it filed under seal. This woman had mental health concerns that began at 12. This was not something that was conflated for purposes of the defense. She was 19 years old at the time.
Tell me the history of the defendant psychological.
She had her first neuropsych exam when she was 12. She had ultimately, and because of this case, she was fully and finally diagnosed, and I can say it now because I argued it in court. It wasn't until she got to Framingham that they diagnosed her with schizophreniform disorder, which is a precursor to schizophrenia. It's the age that she is when that typically emerges, especially in women. And that was the history that she was building up to. She had all kind of the precursor signs from 12 on. She had been medicated since high school. She had gone into programs. She had spent time inpatient prior to this and during her teenage years, all in different mental health facilities.
Did you have an expert examine her, or was she examined by an expert?
She was examined by several experts. I hired Dr. Joss. The state's doctor at the time was Dr. Tammy Howe for the Commonwealth, for the court. She was the court clinician. She examined my client, and literally it took months, as I said, before she'd even speak to me. She wouldn't speak to anyone, not in the fact that she refused to talk. She was almost just non-communicative. And the state hired, his name is escaping me, Dr. Vecchi, I believe was his name. But he also examined her. I gave access to the Commonwealth. Commonwealth wanted to interview Ms. Hannah with their own doctor. I went out to the Worcester Recovery Center with him. He spent a couple of hours examining Ms. Hannah, and then his recommendation was that she remain there for the time being until she could be brought to competency and dealt, and then brought into court. And it was after several months at Worcester Recovery Center, then she was transferred to the psychiatric unit at Framingham, excuse me, where she was properly diagnosed with schizophreniform disorder and properly medicated for the first time in a long time. And once they balanced the medications, she was unrecognizable to me as the person I met way back when this horrible incident happened. I've spoken with her since, and she's just a different person now.
Was there any indication at the time of this terrible incident that she suffered from pre-schizophrenia?
At the time, the diagnosis was not on the books, but there were signs that she was in a manic state, and those are documented. There were other facts that would have precluded a full mental health defense. But as I said to Judge Drexler, and I would repeat it now, there was not a not guilty by reason of insanity that I saw as the defense attorney. However, but for mental health, we would not have been in front of him with the case that we had.
Tell me, if you remember the charges against this woman, lady.
There were counts of, there was kidnapping, there was assault and battery with a dangerous weapon. I believe I have her indictment packet. She was charged with kidnapping, assault and battery upon a child, injury resulting, breaking and entering in the nighttime, and assault and battery, dangerous weapon, child with a child under the age of 14.
Yeah. Yeah, I mean, I heard Counselor Devaney describe the case. Is that accurate to your knowledge, what she had done to the young child?
Not according, the level of injury that was reported to me in the medical records does not necessarily comport exactly with what I heard from Counselor Devaney.
Okay. Well, having represented people with schizophrenia, young people too, young teenage people with schizophrenia and people in their 20s, if she was suffering from pre-schizophrenia, you know, where we all know that they hear voices, and was described to me by one of the best schizophrenic doctors in Massachusetts. They said those voices to somebody with schizophrenia are absolutely taken as the truth, and nothing can dissuade them from that. It is why it's such a troubling disease. It causes so many problems. And look, there's no doubt what she did was horrendous, horrific, terrible. To me, describing what she did in itself, and I'm not a psychiatrist, in itself is proof of the insanity. To do that to a child is not done by somebody that's rational or sane. It's somebody suffering from a mental disorder that they cannot control. So you said that the government had asked for a 10 to 15, was it?
I believe it was a 10 to 12.
10 to 12.
My recollection.
Okay, so at the time she pled, how much time did she have in the facilities credit?
She had just under a year.
Okay, so I know the guidelines have changed somewhat on time you can, good time you can get in prisons. Today, it's basically you can get up to 15 days a month.
That's right.
So let's assume it was some sort of that back then, probably a little bit less. Let's say it was a third. And when they changed the prison system eligibility for parole back in the 90s, I believed it was a mistake, and most correction officers I spoke to believed it was a mistake, because what it did was it took away parole eligibility for a lot of people, and sentences of 5 years and 5 to a day, or 10 years to a day started coming out. And what it did was, for people that worked in the prisons, it was a nightmare, because inmates could do whatever they wanted, just about, without getting charged with a crime, and still get out at the end of their sentence. Where the old system was, I thought, much better system, where if you went in a state prison on a nonviolent felony, and let's say you got 6 years, you walk through the door on a nonviolent crime with 4 years of credit. And as long as you behaved, as long as you did what you were told, as long as you didn't abuse anybody, you kept that 4 years in the bank. But if you had a fight, or you got a D report, or you caused some injury, or you disobeyed a guard, you started to lose the time you had in the bank. So what it did was it kept inmates from doing those kind of things because they didn't want to lose that time. They wanted to get out as soon as they could, obviously. With felonies where there was violence, you went in with 1/3 credit in the bank that you could only lose by your conduct in the facility. It was a great way for the correction officers to keep inmates in line. They didn't want to lose that time. They did away with all that, so be it. But even if it was 1/3, she had already done a year. So if she was down to 9, she'd get a credit for 3. She would be down to about 6 years of time in, probably less than that if she did a lot of programs. So how much time has she done now?
She's, she got a 5 to 7. She was sentenced in 2016. She's probably looking at a release date of April of next year.
So she's done 4 years already, approximately?
Yes. She did not make parole. I didn't handle the parole hearing. I had nothing to do with that, but
Yeah.
she's
Okay,
she's
so
going to do most of the 5.
okay, and so she'll probably hit the 5 the next time she goes up for parole, around
Yes.
5.
Yes.
Okay, and of course we know they don't have to parole, or they can keep her to the 7 years. But most inmates get paroled if they've behaved and they're doing what they're supposed to do. So I'm sure some of the decision by the parole board, because of the emotional aspects of the case and the terrible the victims suffering so much went in, and I'm sure it was very emotional.
I'm sure it did.
So she's going to do, probably before she gets out, as much time, or pretty close to it, that she would have gotten if the government's 10 years was accepted by Judge Tom Dressler.
Correct.
Agree?
I do agree.
Tom
Yes.
Dressler, yeah. So Tom Dressler was not only a judge, but he was a father and handled some very difficult cases in his career. So if he did,
Can't hear you, Bob. You're frozen.
We
Now
can
I
now,
can hear
thank
you.
you, Counselor. Yes, we can hear you now, sir.
so it seems to me, if there's criticism, and I don't believe there should be, even with the DAs, but the TA recommended 10 to 15. So if the net result is she's going to probably leave prison in the same time period as
Can't hear you, Bob.
I'll send him a text. Can anyone hear Council Jubenville? Can anyone hear Council Juben? Can you hear me?
I can hear you. I cannot hear Counselor Jubenville.
Attorney McNeil, can you hear me? I can't hear you.
Yep, okay, now I can.
Okay,
I
Council,
can
Can you hear me? Can you hear me?
we can
just
hear you
now.
now, Council Jubenville. Thank you.
Okay, I'm sorry about that. I forget the hell where I was, but in any event, I was talking about Tom Dreschler, who certainly knows criminal law as well as most.
Sharon Casey
And for
has
him, it
asked
must
me
have,
to send you a letter that needs to be,
Mary, you're live. All right, go ahead.
yeah. So Tom Dreschler, I'm sure, did what he thought was right involving the case and taking everything into consideration. The damage done to this child, this poor child, the criminal record of the defendant, the history of medical conditions and mental conditions, and he made that decision. And I wouldn't criticize him a bit for that. You know, in our system, it seems like judges are one decision away from criticism for doing something that somebody says, you should have done this or you should have done that. People that weren't even in the courtroom. They didn't hear the arguments. They didn't listen to the arguments by both sides, and they make an opinion that they're right and what was done in the courtroom is wrong. So I don't hold much stock in that unless you were there, unless you knew the facts of a particular case. So I don't think that's something I could ever criticize you on. And the end result is, I forget who said it, Councilor Kennedy, maybe, in the end, it was the judge who made that decision based on recommendations from both you and the government. So I don't fault you at all on that, quite frankly. And I had a bunch of other questions for you, but I've taken enough time and it's hard for me to get through, so I don't want to keep it up. But thank you for your time, and thank you for being a defense lawyer and defending citizens of this Commonwealth and taking your oath of office seriously. Thank you very much. Thank you, Madam Chair.
Thank you, Council Jubenville. And yes, I will take credit for saying that the judge did have the final say in the sentence. And we trust his judgment for it. So with that said, I don't have any further questions. I knew that this case was one of the biggest cases you've ever tried, as you disclosed, and a tough one on so many levels of humanity and compassion. And I frankly, again, my heart really feels for this family. The burden they must feel for the introduction of this woman to their child that then committed a horrific crime against their child. But it looks, it sounds, it seems that you were the best and most compassionate attorney that perhaps both sides could have had to get somebody help and to make sure they understood, which was not the case initially, that they had committed a very heinous and serious crime. And I do commend you on that. To you know, sometimes it takes a lot of listening and time and patience to get somebody to the point where they can admit that they were wrong, and we certainly have all been. But anyway, with that, I'm going to adjourn this hearing. I will put your name into nomination next week, and thank you very much for your time, and to your witnesses for appearing today. With that, the hearing is ended. Thank you.
thank you.